This is Law Bytes, a podcast with Michael Geist.
Since 2014, Vladimir Putin has been conducting information warfare there and throughout the world. As I said yesterday, we will be asking the CRTC to review Russia Today's presence on Canadian airwaves. But it's important, Mr. Speaker, what separates us from countries like Russia is that this decision is in the hand of independent regulators, not in the hands of politicians.
The Russian invasion of Ukraine has sparked international condemnation and a race to levy sanctions and undo long-standing connections to the country. Responses have included demands that Russia Today, a television network backed by the Russian government, be removed from cable and satellite systems. Companies such as Bell, Rogers, Telus and Shaw have dropped the service, but the desire for a longer-term regulatory solution has brought the issue to the CRTC. Working with a strict 2-week deadline, last week the CRTC ruled that RT and RT France, the French language version of Russia Today, can no longer be distributed by Canadian television service providers. Monica Song is a partner with the law firm Dentons and one of Canada's leading telecom and broadcast lawyers. She served as a member of the government's Broadcasting and Telecommunications Legislative Review Panel and has taught as a part-time professor at the University of Ottawa for many years. She joined me hours after Ukrainian President Volodymyr Zelensky spoke at the House of Commons and a day prior to the CRTC ruling to unpack the case before the Commission and assess the broader implications around due process and content regulation. Monica, thanks so much for joining me on the podcast.
Thank you for having me, Michael. Happy to be here.
Okay, I'm really glad that you've taken the time to join. It's obviously a difficult time in the world. We're recording this just hours after Ukrainian President Volodymyr Zelensky addressed the House of Commons. And as we record this prior to an expected decision from the CRTC regarding the distribution of RT Russia Today, which is expected imminently. So with that context in mind, things certainly could change by the time this episode drops. I wanted to talk about the RT issue, the role of the CRTC, and some of the broader implications. But why don't we start with a bit of background? Can you bring listeners up to date on the process that's currently before the CRTC with respect to RT distribution?
I wanted to start off in this background, setting of the background, to discuss first of all, the type of service that Russia Today is, exactly what status is in play before the CRTC in Broadcasting Notice of Consultation 2022-58. So Russia Today is what is known as a non-Canadian programming service. It doesn't hold a license, but the way that it is distributed in Canada, at least by traditional broadcasting, is to be distributed by broadcasting distribution undertakings, i.e. cable companies or satellite distribution companies. And in order for a non-Canadian service to be distributed by cable distribution companies or satellite distribution companies, the service needs to accede to a list that is called the non-Canadian programming services list. And so the status that is jeopardy, or that is being considered by the Commission in the proceeding that you mentioned, Michael, is Russia Today and Russia RT France, which is the French language version of it, status on non-Canadian programming list. The second thing I wanted to, set by way of context to make the rest of our discussion easier to follow is that RT and RT France are a special subclass of non-Canadian programming service, i.e. they have been authorized as news services, so non-Canadian news services. And the rules or the framework that the Commission applies for non-Canadian news services was set in Broadcasting Public Notice 2008-100, so quite dated now, going back to 2008. And it's important to start there because in that 2008 policy, the CRTC basically established that absent clear evidence that a non-Canadian news service will violate Canadian regulations, such as those regarding abuse of comment, the Commission is generally predisposed to authorize non-Canadian news services for distribution in Canada on the basis that the importance that the Commission places on diversity of editorial viewpoints. So those two, I think that both the nature of the service that we're talking about, that it's a non-Canadian, not licensed service, and that it was originally authorized back in 2008 under this generally permissive framework for the authorization of non-Canadian news services, is necessary context to the discussion that we're going to have. I think the more recent history is pretty well known. Starting in the week of February 21st, Vladimir Putin formally recognizes the independence of the Donetsk People's Republic and the Luhansk People's Republic. Within 3 days or so, the Russian armed forces launch an assault into Ukrainian territory. So that's February 24th. Within 3 days of that, so by February 27th, the largest cable and satellite distribution companies in Canada, so those undertakings controlled by BCA Inc., Rogers Communications, Telus and Shaw, announced that they are pulling RT, and to the extent that RT France was being distributed by these undertakings from their channel lineups. Within the very next day, Prime Minister Justin Trudeau announces that he has asked the CRTC to trigger a process to review RT's ability to broadcast in Canada, i.e. RT's status on the non-Canadian programming services list. And on March 2nd, an order in council is issued by Cabinet to the CRTC under subsection 15 sub 1 of the Broadcasting Act, asking the CRTC to study and report back within 2 weeks of the date of the order in council on RT status in Canada. The record of the CRTC proceeding closed on March 8th, so within, I believe, 5 days or less of the issuance of the notice of consultation on March the 3rd. And by my calculations, as you mentioned, Michael, a decision a report from the CRTC is to be issued within the week.
Moving incredibly quickly, of course, is the attack and war in Ukraine would suggest. We've seen an enormous public response. We saw a response from the companies as well. I guess it does beg the question. The companies in that timeline took the step to remove distribution of those services from their distribution services. To what extent is this then even needed? Is this sort of formalizing that process in some way? Is this sort of creating sort of a legal position that would preclude them from reinserting it? In a sense, what is the need for this particular hearing before the CRTC, given that the companies themselves took the proactive step, in effect, to remove the services themselves?
That is a very good question, Michael. We don't have visibility, obviously, into the arrangements between the large cable and satellite distribution companies, the proponent of RT and RT France in Canada, the ethnic channels group. It may relate to that relationship and the terms and conditions upon which Bell, Shaw, Rogers, Telus ceased distribution of RT and RT France in Canada. It's hard to know, but I do think that there's an interesting issue to be perhaps fleshed out with respect to the why. That question that you've asked. At its inception, the issue is one of state-to-state relations, so between Canada and Russia and the rest of the world. And yet the government of Canada has seemed very eager to thrust this into the realm of press freedom and broadcast regulation.
You did a great job of highlighting where this fits within the broadcasting framework and when the CRTC established some of these rules. Have they denied over the years? I mean, you mentioned they take a fairly liberal approach, especially with respect to news services. Has the CRTC denied distribution in the past, or have they revoked distribution in the past, or is this something that's new?
Certainly, the CRTC has denied authorization to non-Canadian programming services to be added to this so-called non-Canadian programming services list. But interestingly enough, Michael, the vast majority of these cases where authority was denied by the CRTC from the outset, it had less to do with abusive comment or false or misleading news, and actually more to do with whether or not the non-Canadian service was in total or partial competition with Canadian specialty and pay services that were duly licensed by the Commission. And so there's like a stable of not huge, but a number of U.S. channels that had previously not been permitted to be distributed in Canada, including FX and ESPN, HBO, certainly household names. And interestingly enough, after these denials, what sometimes happened, not in all cases, but sometimes happened, is that that forced the U.S. Programming service to form a partnership with a Canadian entity and thereby launch a licensed version of the American services in Canada. So certainly there have been denials in the past. In terms of revocations, again, no revocations on the basis that I can recall on the basis of something like abusive comment or false or misleading news breaches. But I can think of one instance where a non-Canadian programming service was initially authorized under one genre, right? And then over time, it transformed itself and became competitive with a authorized or licensed Canadian service. And therefore, the status on the non-Canadian programming list was reviewed. But it's very rare. And as I say, the issues at stake were more about total or partial competitiveness with existing Canadian services and not anything like the issues that we're seeing here. The one precedent that is somewhat parallel, although it did not involve either a refusal to authorize distribution or revocation of authority to distribute, is the Al Jazeera case, which you probably recall, Michael. So Al Jazeera is also a news service, and it has always been authorized, but under very unique conditions imposed initially on BDUs, broadcasting distribution undertakings that wanted to distribute Al Jazeera. And there was a lot of comment and debate around potential abusive comment in the authorization of Al Jazeera.
Interesting. So we do have some history, although this is, for the most part, uncharted territory, especially for this particular kind of concern that's arisen. Given that this is new and some of those kinds of concerns, it is striking just how quickly all of this is moving, and in some ways, of course, dictated by world events. But that has sparked, I think, some amount of concern about the independence of the CRTC. The commission typically takes months for hearings, but in this case, the desired outcome from the government was made pretty clear. Commission put its position, within almost hours or at least days of that being put forward. And this is on a rocket docket such that within a couple of weeks, we may get a decision. Do you think there is any reason for concern with respect to how quickly things are moving? In a sense, is due process possible in this kind of very fast time frame?
Obviously, the tight time frame for a report back to the governing council in this proceeding is noteworthy. It is, as you all have already pointed out, Michael, a little bit difficult to see the urgency, given that RT has already been dropped by the largest broadcasting distribution undertakings that carry RT. And so we really have to wonder why the extremely tight time frame, given the practical reality on the ground. I also think that it's interesting to look at the what I understand are sort of parallel proceedings in other jurisdictions. So Ofcom, which is the British equivalent of the CRTC, is also looking at RT and the extent to which the content may constitute abusive or false news. But that process, as I understand it, is proceeding on the normal timeframes of Ofcom. So there have been more than 24 complaints apparently filed with Ofcom regarding specific instances of improper or inappropriate content that is contrary to Ofcom's regulations and rules. Ofcom is seized of them. Ofcom is looking at them. In parallel to that, the British government, as a state actor, has taken certain actions vis-a-vis another state, i.e. Russia, via not the broadcasting regulatory regime, but sanctions legislation and tools. So it's interesting to, on the urgency question, to not only address it kind of straight on, but to also look at it from the practical perspective and a perspective of, okay, well, what are other countries, some similarly situated countries, doing about RT and on what kind of time frame. Secondly, when you have such a compressed time frame, a natural question arises as to the quality of the evidence that the regulator has to work with. I note that the quality of the evidence has to be assessed in light of the issues that are set out in the consultation document. And the Commission has clearly framed the consultation and the basis of any eventual report or decision that it issues on whether or not RT broadcasts contain abusive comment. One has to ask, what evidence of abusive content is the Commission does the Commission have available to it based on the record of the comments that it received? Is the Commission going to rely on evidence outside of the record? I can't pretend to have read every single submission, but although there were hundreds, so over 400, and I believe almost 450 submissions or interventions filed, many were from individuals and did not have the sort of specific examples or descriptions of programming alleged to be abusive that would speak to the issues as framed by the Commission in its notice of consultation. So I think there's definitely, and the time frame certainly does not help, some questions about arbitrariness, or potentially, depending on what the report looks like, of course, from the CRTC, the quality of the evidence. Thirdly, when you're dealing with a proceeding to consider, I guess, banning or removing authority to distribute a programming service, you have to ask yourself, okay, is the remedy proportional? We will have to see how the CRTC deals with that. I did mention, just in the context of what Ofcom is doing in the United Kingdom, that in parallel with the Ofcom proceedings that are proceeding on a much slower normal pace, that the UK government, along with the EU, had taken sanctions-based measures against RT and the satellites undertakings that it relies on to distribute its services. It's not a secret, as everybody knows, that the impetus for this proceeding comes from Governor and Council, comes from the government of Canada, and you have to wonder. An actual question arises as to whether the government is sort of forcing a censorship mantle upon the CRTC. It appears to be forcing the Commission to assume jurisdiction over questions of speech in the sphere of broadcasting, which the CRTC has willingly accepted exceedingly rarely in its history. It's not a mantle that the CRTC wears gladly. If it can avoid it, it does. And yet, in the context of a major reform to the Broadcasting Act in Bill C-11, you see the government being seemingly quite eager to turn what could be, in my view, a state-to-state issue that perhaps could be addressed using other statutory tools and measures into a arguably a free press and broadcast censorship issue.
Okay, wow, that last point really begs a whole series of questions. I want to touch on a few of them because I think you really raised some interesting points, both with respect to Bill C-11, the legislation before the House right now, but even the implications of moving the CRTC more towards speech regulation, which this does. This is obviously a specific case involving RT, but do you have a sense that there's the prospect that this becomes a precedent that then either expands into other areas or people start pushing the CRTC to become more active on some other issues? There have been calls in the past for the removal of the China Global Television Network from the Chinese government, and some have even now cited Fox News in the same kind of context for those who are who are critical of that network. Could this spiral into a space where the CRTC suddenly now finds itself being asked to make judgment calls on a whole range of these kinds of services?
I think that will have to await the reasoning of the CRTC. I come from a legal, broadcast regulatory, and administrative law perspective. That's what I'm trained in, and so that's why I focus so much on what are the terms of the notice, the public notice of consultation. What is the quality of the evidence? It really, I think I'm going to sidestep your question because it really would be speculative. Could it? Maybe. Should it? Probably not. Is there a way to avoid it? I think it all depends on how the CRTC presents its reasoning in this report.
Okay, that's fair, but while we're entertaining possible speculation, you've already cited at least one possibility of how this could have been addressed at a state-to-state level. You have other thoughts of how the government might have handled this differently, and even how the CRTC could try to handle this in a way that would foreclose, to a certain extent, some of the possibilities of this spiraling into other areas?
Yeah. What leaves me scratching my head is what your initial question, what pushed the government to refer this question via Section 15 of the Broadcasting Act to the CRTC. Did it have any other tools available to it? So this kind of strays outside my area of expertise, but it is no secret that Canada, along with its allies, have issued a number of sanctions against individuals with associations with the Russian Federation, as well as specific entities and, of course, corporate, as well as a part of the structure of government in Russia under the Special Economic Measures Act, and in particular, Russia regulations. My understanding is that the regulations that establish the lists of sanctioned entities, so entities against which persons and entities against which sanctions have been imposed, can be amended very quickly. So in as little as 24 to 36 hours or less. Since the events of February the 21st, in fact, the Russia regulations have been amended by Governing Council at least 3 or 4 times. But these are not regulations that are hard to amend. The state of Russia, so the federation itself, is not named as an entity or as a state. As the state itself is not, but there are hundreds of individuals and entities listed there. So, I guess one question that arises, and I'm not an expert in sanctions law, but certainly I have friends who are. Why did the government not consider adding the state-owned news agency, RIA Novosti, or other agencies or departments of the Russian state that are involved in the funding or operation of Russia Today and Russia Today France to the schedules of the Special Economic Measures Act Russia regulations? I don't know what the answer to that is, but it seems to me that could have been one possibility. And to the extent that happens, and maybe that's not the only thing that needs to be amended in those regulations in order to provide the necessary legal justification or cover to cable companies or distribution partners in Canada. But were that to happen, my understanding is that that would preclude receipt of certain payments, ongoing payments, even though contracts were entered into prior to the time of the imposition of the sanctions. So notionally, I guess the question arises, why wasn't that means considered? In other jurisdictions, for example, the United States, there is legislation requiring foreign agents to register with the government of Canada. So in the US, there's a law dating back to the 1930s called the Foreign Agents Registration Act that focused on foreign propaganda machines. In modern times, its purposes have evolved somewhat, but interestingly enough, originally that legislation was designed to sort of ferret out and expose foreign agents that might be operating in your jurisdiction or your country. That's obviously not something that could have been imagined and implemented in the space of the events in Ukraine the last couple of weeks. But arguably, the events in Ukraine have not been only 2 weeks in the making. There was excellent reporting in Canada in the Globe and Mail about RT and RT France, 4 or 5 or more years ago with the original Russian annexation of Crimea, and questions were asked back then in articles that appeared in the Globe as to, okay, why is this entity, which some have characterized as being a propaganda machine, still allowed to broadcast in Canada. On the CRTC side, the CRTC does have the power to impose certain conditions on the approval of non-Canadian programming services. We saw that in the Al Jazeera case, as I have already alluded to. There were extensive public consultations conducted with respect to authorizing Al Jazeera to be carried in Canada. So the CRTC could have adopted rules that require BDUs that carry state-funded, owned, or controlled media to disclose their foreign ownership or funding. One can imagine rules that require BDUs that carry state-funded, owned, and controlled media to be transparent via viewer advisories as to sponsors of content. This could conceivably encompass payments made by distribution undertakings to carry the programming. I note that, in the CRTC's new annual digital media survey, that this is the very kind of information that the CRTC intends to collect with respect to digital media undertakings that are also not licensed necessarily in Canada. One can imagine that there could have been a number of things that both the government and the CRTC could have considered doing. Admittedly, perhaps not in a 2-week time frame, but as I say, I think the RT issue has been around for a lot longer than the past 2 weeks.
I think that's a really interesting perspective in terms of how this has been bubbling under the surface and perhaps not even under the surface for quite some time. You know, this discussion wouldn't be complete without some discussion of C11, and you kind of provided a nice segue there with respect to the CRTC's interest in more data when it comes to digital media services. Now, C11, of course, currently before the House, and it envisions a new class of undertaking, the online undertaking. The government has emphasized that those undertakings under the bill would be subject to registration, not licensing, but there certainly does seem to be some pretty obvious parallels, which of course begs the question, is it possible that we could see ourselves move into the same kinds of questions, but this time with respect to internet-based services, which of course is a significant additional complication, as we're not talking about quite literally a handful of major providers, but rather whether or not there are steps taken to try to limit access of internet-based websites or internet-based services, sort of along the same kind of lines that we see developing here.
I'm wary of arguing too much by analogy or making this too analogous. I think there are some key distinguishing features about RT. Number one, it's a news service, and number two, it's state-owned and controlled. And so it's not clear to me that the approaches that we should take vis-a-vis state-owned and controlled news services are necessarily transposable, holus bolus, with the same heavy-handed or light touch to all online undertakings delivered over the internet, which come in many different shapes, sizes, and flavors. The 2008 CRTC policy on authorizing foreign news services was very broad-minded, certainly very anchored in the belief that the free exchange of ideas was key to a healthy democracy and to discourse in our democracy. And so there's a fundamental policy question that arises, I think, as a result of RT and its history in Canada as to whether or not we should stick holus bolus to the default position of the Commission regarding foreign news services that are controlled by state actors in the name of Canadians' access to alternative editorial voices. So there's clearly the situation does raise that fundamental policy issue. I think that, and so I'm really answering these questions more from a CRTC perspective than from a government perspective. As I said before, when we're dealing with foreign actors and either situations approaching, armed aggression, war, that at some point, perhaps the solution should be a state-to-state solution and not one of broadcast policy. Coming back to your question, the second solution set, I guess, to the RT problem, we should really look at, what are the conditions of service that are appropriate. I think this will somewhat resonate for you or for any student of Bill C11, in that conditions of service as opposed to conditions of license is a concept that is being introduced in Bill C11 for online undertakings. But that questions such as will the foreign service and in particular foreign news services that are controlled by state actors be subject to additional disclosures and transparency requirements regarding state control and funding sources via viewer advisories or what have you. This kind of system is reminiscent of systems that we already have in place for example, election advertising, right? Where we require a great deal of disclosure and transparency because the messages are inherently partisan and political in nature. Query whether that would be appropriate as a measure to allow consumers to be more informed about their consumption of information from foreign news services that are controlled by state actors. Should foreign services, and in particular foreign news services controlled by state actors, commit to adherence to Canadian journalistic ethics and standards? A la Canadian Broadcasting Standards Council, the CBSC, or perhaps even the Facebook Oversight Board. Finally, in terms of administrative discretion, will the CRTC delegate administration of journalistic ethics to an arm's length body or adjudicate such cases directly when it comes to foreign news services controlled by state actors? Or will it adopt a complaint-driven system of progressive discipline? And what would that look like for a foreign service? So they're not easy questions, but that would be the the sort of the bucket of policy and I guess mechanistic questions that you could start looking at these issues with.
It's interesting to think about some of those different options that the CRTC would have. I guess for me, just to wrap up, I mean, I guess I recognize that we're dealing with the specific bucket if we're talking about state-owned news, but there's of course state-owned news services and websites that are available online as well that will raise the same questions, really. I mean, essentially, if there's a decision made that, this content is enormously problematic and propaganda or whatever the particular term happens to be, surely there is going to be some amount of pressure to say, well, just you've stopped it through the broadcast distribution system. Are you not in a position to stop it in terms of its availability through the internet? And CRTC might say, well, no, we adopt net neutrality rules and we're not in a position to do that. But I guess the question for me at the end of the day is, does C11, given that it seeks to bring these services, whether state-owned or otherwise, into the Canadian Broadcasting Act, does it kind of move us closer to a world in which we begin to see those things and perhaps entertaining people raising possibilities of website blocking or other kinds of measures, essentially under the same guise of saying, well, we're trying to create an equivalency here. We've tried to remove it from the broadcast distribution system let's try to remove it from the online undertaking system as well. Yeah,
I see certainly some parallels and practically speaking, why your question is relevant. Certainly RT had a huge social media presence. I mean, it pivoted just like everybody else did from traditional broadcasting to online broadcasting, and just like all the large Canadian BDUs ceased to distribute RT and RT France, so have YouTube and Twitter and Facebook and et cetera. I want to maybe shift your question again. I hope you don't mind. It's not so much about blocking or not. I don't think the question when it comes to this area really comes down to blocking or not. I really do want to stress the point that the RT issue has been kicking around for years and years, and nothing was done. So now maybe the choices are stark. Maybe it does come down to blocking or not, and query whether that should be done via a CRTC proceeding or whether that should just be done in what I call a state measure under the special Economic Measures Act. But I don't see it so much as a question of blocking or not. I see it more as raising an opportunity for us to think about the need for a common understanding of how we're going to enforce or create and enforce community standards on the internet? That may be a controversial question for some, but whether a state actor does it, whether the government of Canada does it, or some other government does it, or the companies themselves that operate these services and platforms do it, it's coming. And that is the rubric within which, in my view, unacceptable content on the internet, it should be seen. I guess the questions that we should be asking ourselves, and there's really no clear answer and therefore no right answer, but we can see it from everything that's happening around us is, for example, are we going to content ourselves with entrusting community standards with respect to online audiovisual content up to online platform providers to devise and enforce, in whatever manner they choose, perhaps consistently, perhaps inconsistently, perhaps transparently, perhaps non-transparently, but are we going to entrust that role to them? Are we content to allow state-owned and controlled media outlets to broadcast without making mandatory disclosures and being transparent about the source of their perspective? Are we content to allow the amplification of certain political speech through money or influence or power on the internet and leave that up to market forces, essentially? Or are we going to sit by and watch the fascinating social experiment that, Facebook's oversight board represents and see that unfold for a few more years, maybe, before we decide what standards of publication, notice, due process, and enforcement in relation to community standards on the internet we want to govern ourselves by? Or should we have the foresight as a society to devise a system to deal with hard cases of imminent or actual harm to human health and safety, war or terrorists or other emergencies or grave threats to electoral fairness and democratic institutions? It may not be a single mechanism. It may depend on the nature of the service and the threat, but if we were more proactive about thinking about how we want these questions to be decided, it shouldn't come down to whether or not it's a blocking or no blocking scenario. I want to just leave with you perhaps the thought that the CRTC has never, I don't rush to the defense of the CRTC every day, but the CRTC has never willingly been a broadcast censor. In my experience, it has consistently eschewed that role, if at all possible. It has, created a system of broadcast standards that is largely run by arm's length third parties. It is backstopped by conditions of license on traditional license undertakings that it has historically regulated, but it has, as a result, very seldom had to step in to censor a broadcaster in Canada. The one exception being Shaw FM, but even there, like Shaw FM was given like years of reprieves and warnings and lots of chances to address the issue itself before the CRTC actually pulled its license. Perhaps that system is unworkable in an online universe. Michael, you probably thought deeply about these issues yourself, but if I could just shift the discussion into looking at it less as a black and white, block or no block, into something a little bit more proactive to avoid that blocking scenario, I think that would advance the debate.
Yeah, thanks. I mean, certainly you've given us a lot to think about. I agree with you. If we end up in a space where it's just block or no block, that puts us in a difficult position. And while it's true that the CRTC, has taken the kind of positions that you've just described, I think it's also fair to say the CRTC has never been granted this much power if C11 becomes law over this wide a range of speakers and speech and services when you start moving into the internet and the audiovisual world. So it's new territory for the CRTC as well, which of course I think for some is why There are questions both about how much guidance the government should provide, as well as some questions as to whether or not the CRTC is the best placed entity to deal with some of these kinds of questions. Certainly some things are a nice fit, but perhaps not all. Definitely lots to think about. And this RT case, while obviously attracting a lot of immediate attention, may well have some of the ripple effects that you've just described as we continue to sort through some of the real thorny challenges when it comes to broadcast and now the internet. And so, Monica, thank you so much for coming on the podcast and helping sort through those various issues.
Thanks a lot, Michael.
That's the Law Bytes podcast for this week. If you have comments, suggestions, or other feedback, write to lawbytes@pobox.com. Follow the podcast on Twitter @LawBytesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bytes podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.